Good afternoon, all. This is Rick Hackett with Community Planning and Permitting staff. We are recording. You may begin.
Thank you. Good afternoon, everyone. It is Wednesday, October 5th, 2022 at 4:02 p.m. And today's meeting of the Board of Adjustment for Boulder County will now come to order. We will begin with a roll call vote of the Board of Adjustment members. My name is Eric Mouse. I am the chairperson of the board today. Mr. Robert Ukile, are you here?
Present.
Mr. Bill Walters, are you here?
Present.
Mr. George Gerstle, are you here?
Present.
Mr. Scott Rudge, are you here?
Scott Rudge, present.
Thank you, everyone. I want to remind you of a couple ground rules. Obviously, we are here virtually today due to COVID-19 concerns. Information on how to participate in the virtual meeting has been posted on the Board of Adjustment webpage at www.boco.org/BOA. There will be an opportunity to remotely provide public comment on the subject dockets today during the respective virtual public hearing portions for each item. The chairperson will provide instructions about that when we get to each item on the docket agenda. I want to remind all of the Board of Adjustment members of the following. First, please identify yourself before speaking and speak slowly and clearly. All votes will be roll call votes. Please be sure to have your video on if possible during the hearing, but please remain on mute until you are ready to speak. When you begin speaking, the proper way to identify yourself is Board of Adjustment member and then your name. And it may help you to keep the participant list open on Zoom so you can see who is speaking. The person who is speaking will be bolded. We have two items on the docket for tonight. The first is the nomination of new officers for the next year of the Boulder County Board of Adjustment. And the second is docket AP 22003 Martin Marietta Appeal SU-96-18. An appeal from the Community Planning and Permitting Director's determination that special use permit has lapsed. However, we'll begin with appointing new officers for next year, and the new chairperson will take over the meeting and run it. So let's start with the vice chair. Do we have a nominee for vice chair this year? Hearing no nominees, I'll nominate Mr. George Gerstle for the position of vice chair for the next year of the Boulder County Board of Adjustment. Do I have a second?
This is board member Robert Ukile. I second that.
Okay. Is there any discussion? All right, hearing no discussion, we'll take a roll call vote to appoint Mr. Gerstle as the vice chair for the Boulder County Board of Adjustment. As chairperson Eric Moutz, I vote yes. Mr. Robert Ukile, how do you vote?
Robert Ukile, yes.
Mr. Bill Walters, how do you vote?
Bill Walters votes yes.
Mr. Gerstle, how do you vote?
George Gerstle votes yes.
And Mr. Scott Rudge, how do you vote?
Scott Rudge, yes.
By unanimous vote, Mr. Gerstle, congratulations. You are the vice chair of the Boulder County Board of Adjustment for the next year term. We will now open the floor for nominees for the position of chairperson for the next term. Do I hear any nominations for chairperson?
I nominate Robert Ukile. This is George Gerstle, BOA member. I nominate Robert Ukile as chair.
This is Board of Adjustment chairperson Moutz. I will second that nomination. Does anyone want to have discussion of the nomination? All right, seeing no discussion, we'll proceed with the roll call vote. I am Eric Moutz, current chairperson, and I vote yes on this matter. Mr. Robert Ukile, how do you vote?
Robert Ukile votes yes.
Mr. Bill Walters, how do you vote?
Bill Walters votes yes.
Mr. George Gerstle, how do you vote?
George Gerstle votes yes.
Mr. Scott Rudge, how do you vote?
Scott Rudge, I'll abstain.
All right. Well, by a vote of 4-0 with one abstention, Mr. Ukaili is elected the chairperson of the Boulder County Board of Adjustment for the next term. I have to admit that I don't remember, based on past practice, whether the chairperson takes over this meeting after being elected, as I suggested a moment ago that they would, or if I should continue to run the current meeting. Mr. Hoyt or someone from Boulder County Planning and Permitting, could you enlighten me, please?
Yes, normally, this is Larry Hoyt, the board's attorney. Normally, the newly elected chairperson takes over as chair for the rest of the meeting.
Excellent. Well, congratulations, Mr. Ukaili. I will turn the virtual gavel over to you. You are now the chairperson, and I will happily retire to being a rank and file member of the Board of Adjustment. The meeting is yours.
Thank you. This is board member Robert Ukaili. Thank you, and thank you for serving for chair for the previous year. So continuing on with the meeting, we have one item scheduled for today's Board of Adjustment meeting currently. At this time, I'll take an opportunity to explain the public hearing process. There will be
Chair Ukaili, this is Larry Hoyt again, the board's attorney. As set forth in the agenda, it appears that item 4.1 on the agenda needs to be tabled by action of the board.
Thank you. And sorry, Larry, what's the number on that?
Yeah, it's docket AP 22-0002 Billingsley BLD appeal, and it needs to be tabled to the November 2nd, 2022 board meeting.
Thank you. So
moved. George Gerstle, so moved.
thank you. Is there a second?
Scott Rudge, second.
Thank you. Any discussion? Hearing none, I'll take a roll call vote on the motion to table AP 2022-002. This is Chair Robert Ukaili. I vote yes. Board member Mounts? You're on mute, sorry.
I apologize. I vote yes.
Thank you. Board member Gertzel,
George Gerstle votes yes.
board member Walters,
Bill Walters votes yes.
thank you. And board member Rudge,
Scott Rudge, yes.
thank you. So the board unanimously approves the motion to table AP 2022-002 until November 2nd. We'll now move on to the next item, which is AP 22-0003 Martin Marietta Appeal SU-96-18 has lapsed. I'll take this at this time. I'll take this opportunity to explain the public hearing process. There will be an opportunity to remotely provide public comment on the subject items during the virtual public hearing portion of each item. The order of presentation will be first we'll hear from staff, then the applicant, and then we will be accepting public comments from any individual who wishes to speak. Some people may have signed up in advance and we will call on you first. If you did not sign up for public comments, you may sign up in the chat. Please direct all your questions and comments to the board. The chair will direct any questions that arise during the hearing to the appropriate party. Once we are satisfied that we've heard all relevant testimony, the public hearing will close. The board will then discuss the merits of the case and come to a decision. Any member of the public will have a chance to speak, even if you didn't sign up from the BOA web page beforehand. Once those who've signed up in advance have spoken, I will call on any additional members of the public to speak. If you join by computer, please sign up by submitting your first name, last name, address, and the docket number in the chat box to the right. As each person who has joined by computer and signed up to speak is unmuted, Zoom will adjust your participation status so that you can speak and be seen via video. Once you've finished speaking, Zoom will place you back into the room as an attendee. If you dialed into the meeting via phone, please raise your hand by pressing *9, and we will unmute you when we call on you to provide comment. When it's your turn, the system will request that you unmute yourself with *6. Once you are unmuted, either via computer or phone, if you're called in, please state your name and address for the record before providing comment. Each speaker will be allotted 3 minutes to speak. A timer will be at the end of your speaking time, or I will let you know when your time is up. Time can be pooled at 3 minutes per person for a maximum of 10 minutes. You will need to provide the name and addresses of other people, up to 3 people besides yourself, who are in attendance and donating their time to you. Anyone who is pooling time will need to attend the virtual hearing so we can verify their presence as we would at an in-person hearing. Please do not submit comments or questions in the chat box during the meeting. The chat box should be used for public hearing speaker sign up only. Please remain on mute when possible. The moderators will mute you if we see that your connection is the source of background noise. Members of the public will be unable to share their screens during public comments. Applicants, please have your presentation pulled up and ready to go. I will announce when we are ready for you to present, and at that time, you can share your screen. Opening of the public hearing. This is a public hearing for docket AP-22-0003, Martin Marietta Appeal SU-96-18 has lapsed. We will now hear from staff. Would you, Mr. Case, would you please present the staff report?
Yes, good afternoon, board members. I hope everyone can hear me okay.
Yes.
I'm getting a message on my screen that I'm having audio difficulties, so let me know if there is a problem. And I did want to make one clarification. In the case of this appeal, the appellants, Martin Marietta, will have the opportunity to speak, and then Save Our St. Vrain as an interested party, their attorney will also have time to speak before we go to the regular public. So just wanted to make sure that is clear for folks. And just also another announcement for folks is, I guess we're having some other difficulties with the Zoom features, and we'll be able to promote them on audio, but not have them promoted visually. So we'll be able to unmute them when it's their turn to speak, but we won't be able to have them on video. We're working on getting the appellants and Save Our St. Vrain's representatives into the meeting here so that they can be able to show their presentations and be on video. So bear with us as we work through those. And I'm going to try to share my screen here, and hopefully things have changed here a little bit. So can people see my presentation?
Yes, thank you. Although it's not in slideshow mode, if that matters to you.
Is it now?
No. I mean, no, it is.
Although
Are you seeing?
we
Yes.
can see your notes.
Dale,
You
this
can't-
is Anna Milner, staff. If you go to display settings and go to duplicate slideshow, that should fix the problem.
Thank you. Having audio difficulties here.
And the display settings will be in the upper left there. There you are.
That one. What am I hit? Swap presenter view and slideshow?
Hit duplicate slideshow.
Duplicate slideshow? Okay. And I can't see my notes at all, huh?
You might have to double click on that duplicate slideshow or something.
There you go.
I've got it, but I don't have my notes at all, so bear with me for 1 second. Sorry. Let's stop for a second and try again. Okay, are folks seeing the presentation now?
We are not. Now we are, thanks.
without my notes, correct?
Correct.
All right. Sorry about that. Again, Dale Case, Director of Community Planning and Permitting, and we are here on AP 22-0003, Martin Marietta's appeal of my determination that special use 96-18 has lapsed. This is a brief timeline of events surrounding the application and how we got here. Initially, there was a special use approval approved by the county commissioners in 1973 to mine gravel on these parcels. Some of the parcels involved in this approval. In 1998, the county approved a special review to amend the permit and expand the areas to be mined. It's in resolution 98-32. Lafarge West Incorporated, who was the owner of the mining leases at that time, continued mining and reclamation activities until 2006. In 2011, Martin Marietta purchased from Lafarge and continued reclamation. In 2016, Martin Marietta received approval to slightly modify some of their accessory facilities associated with the special review. In 2016, Save Our St. Vrain Valley Incorporated, SSOVV, requested me to review the status of the special review and whether the permit had lapsed. In 2018, I issued a determination on that request that the permit had not lapsed. Save Our St. Vrain Valley appealed that determination, and I was upheld by this board on a vote of against my determination of 3-2, but it needed a supermajority of 4 votes in order to be able to overturn my determination, and so I was upheld, even though the vote was 3-2 to overturn it. Save Our St. Vrain Valley appealed through the courts, and the Court of Appeal ruled in their favor. So that has brought us sort of how we got here today, and they remanded this decision for reconsideration to address 2 issues that the court called out. Any activity that's directly related to the special use itself, or any authorized accessory uses occurred, and whether there were equitable considerations dictate that the permit has not lapsed. So based on that remand and request, I issued a revised determination finding the permit had lapsed back in April of this year, and Martin Marietta appealed that determination. Okay. So we're going to look first at that no activity related to the special use itself or any authorized accessory uses has occurred so as to present a lapse. So one of the court ordered pieces for us to look at. In 2018 determination, I considered not only mining operations, but also the activities to plan and prepare for mining, as well as post-mining reclamation activities as sufficient to prevent a lapse. At that time, I had noted that reclamation work had continued on the site without a 5-year lapse. However, the Court of Appeals disagreed with this interpretation. The court concluded that the lapse provision unambiguously requires activity directly related to the special use itself or any authorized accessory uses in order to prevent a lapse. The court expressly rejected the argument that reclamation constitutes the special use, holding instead that reclamation is a condition and not sufficient on its own to prevent a lapse. The court also determined that the special use could include accessory uses authorized under the resolution. And the language on that slide is the language around the lapse provision that's in the land use code itself. So it is undisputed that no mining activity has occurred on the property since 2006. While reclamation activities such as fertilizing and reseeding lakes, prairie dog control, and other activities listed in the staff report in preparation for additional mining operations have occurred at times on the site, these activities are not directly related to the special use itself. Rather, they pertain to conditions under the resolution, which are distinct from permissions to mine gravel. As such, these activities are not sufficient to prevent a lapse. Marietta asserts that it conducted testing excavations in 2015. Well, even if I consider the testing excavations to be activities directly related to the special use, which I did not, a 5-year lapse period still exists prior to 2015. Because no mining has occurred for over 15 years, it follows that the accessory uses have also not occurred. An accessory use must be a use customarily incidental to and on the same parcel as the main use. That's in Article 4-516 of the Land Use Code. An accessory use, therefore, cannot exist separate and apart from the principal use. For example, the code allows an accessory structure on a property so long as its use is incidental and accessory to that of the principal use. The fact that additional structures exist on a property does not make it an accessory structure if it is not being used as an accessory to the principal use. Not sure if the slide advanced for you. It has not for me.
Yes.
It did? Okay, there it goes. So it would not align with the court's reasoning regarding the definition of activity under the special use permit to allow the mere storage of equipment in absence of any actual mining activity to be able to prevent the permit from lapsing. This is not to say that an accessory use could never prevent a lapse. For example, had Marietta conducted open mining for a period of time and then spent a subsequent period of time processing the material, activities related to the processing would likely be considered an accessory use, sufficient to prevent a lapse. However, simply maintaining processing equipment on the site for an innumerable amount of time without ever engaging in the principal use does not constitute a use that is customary and incidental to the principal use. Following the court's interpretation of the lapse provision, I have reversed my prior determination and concluded that no activities directly related to gravel mining have occurred on that site for a period of at least 5 years, nor have I authorized accessory uses. As such, the special use permit has lapsed due to lack of activity under the special use permit for at least 5 consecutive years. So moving to the equitable estoppel argument. The second issue, the court remanded for consideration, and the doctrine of equitable estoppel must establish 3 factors as shown on the slide. That there is a change, that it changed its position to its detriment in justifiable reliance on the party's conduct. That the estoppel party intended its representations to be acted on so that the other party was justified in relying on the represented facts, and that the party alleging estoppel was ignorant of the actual facts and reasonably relied to its detriment on the other party's conduct of misrepresentation. The Court of Appeals noted that Eric Heil's opinion, with which my prior determination concurred, also considered equitable considerations. The court therefore left open the option for me to consider equity in this analysis, even if I determined that no activity under the special use permit had occurred for at least 5 years. Although I considered and concurred with Eric Heil's opinion in making the initial determination, I did not base that determination on equitable considerations. Instead, as stated above, I had determined the permit had not lapsed because reclamation activities had occurred continuously on the site. Upon review of the equitable considerations presented by Marietta, I disagree that such considerations require me to determine that the permit has not lapsed for the following reasons. The lapse provision is clearly stated in the land use code. In addition, Martin Marietta's predecessor was specifically informed as early as 2006 in the letter noted above that lapse could occur. Although I don't have information on the sale of the property to Marietta, reasonable due diligence prior to the sale would have informed Marietta of the existence of the lapse provision in the code and in this correspondence. In addition, the code provision was publicly available, and this correspondence would have also been easily available to Martin Marietta via an inspection of the docket file, which is a public record. So continuing on the equitable considerations, in November of 2011, there was a letter addressing zoning violations on the properties. The letter states, although there are no zoning violations on record at this time, this statement does not guarantee you that there are no violations on the property. This statement merely confirms the contents of the county's records at the time and was accurate. Specifically, we were not investigating or enforcing a zoning violation on the property as of the date of the letter, nor reviewing the issue of whether the special use had lapsed. In December of 2016, Marietta requested to modify their approval. The reason the parcels on which the scale and scale house were to be located had been sold to Boulder County for open space purposes, and Martin Marietta wanted to cluster its buildings and operations. The request did not seek a determination as to whether the permit had lapsed, but rather focused on the relocation of structures onto Marietta-owned property. Staff's response noted, based on my research of the docket and the information you provided to me, special use review is not required for the structures you propose. Everything you are proposing was contemplated and approved during SU 9618. Only the location is being slightly modified. Staff's review is clearly limited to the minor modifications to the structure locations. Staff did not review the history of the mining activity on the parcel to determine whether the permit had lapsed. On January 24th, 2017, we sent a letter informing Tetra Tech on behalf of Marietta of the county commissioner's decision regarding the modification request. This letter stated that all conditions of the 1996 special use approval were still in effect. Importantly, the letter states, this department sent a letter to Stephen T. Brown with Lafarge on October 17, 2006, interpreting some of the conditions of approval based on the situation at that time. This letter remains in effect as well and was enclosed. Not only was the 2006 letter informing Lafarge of the potential for lapse referenced in the 2017 letter, it was also enclosed for reference. Thus, Marietta was again reminded of the lapse provision prior to expending any resources related to the requested modification. Because the 2017 determination was only considered a minor modification, and because it made no mention of lapse, neighbors and other interested parties would not have been on notice to provide the community comment or appeal the decision that would affect whether the permit had lapsed. Marietta therefore cannot establish the first element of equitable estoppel, that it changed its position to its detriment in justifiable reliance on the county's conduct. It also cannot show the remaining two elements because the county made no representations related to the lapse and instead reminded Marietta multiple times of the lapse provision. It certainly did not intend for Marietta to conclude that no lapse had occurred. Moreover, Marietta was not ignorant of the actual facts. Instead, It was the entity in the best position to know that mining had not taken place on the site since 2006. Marietta was also aware of the lapse provision, and thus any reliance on the communication cited by Marietta is as a basis for determining the permit has not lapsed is not justifiable. So that concludes my presentation, and I'm asking that you uphold my determination, and I'm available for any questions.
Thank you. Do board members have any questions? Hearing none, I will now ask the appellant to give their presentation.
Good afternoon, members of the Board of Adjustment. I'm Andy Peters. My office address is 950 17th Street, Suite 1600 in Denver. And I am going to attempt to share my screen here as well. There you go. Does that include my notes, or is that just the presentation for you all?
Just the presentation.
Perfect. Well, thank you again for the opportunity to be here today, and thanks to Director Case for continuing the 5-year saga of this this particular special use permit. Martin Marietta seeks reversal of the director's most recent determination that the special use permit 9618 had in fact lapsed due to inactivity. And the reason why here is simply because that interpretation, the most recent interpretation, didn't follow the Court of Appeals direction on remand, therefore shut down a multi-decade operation that remained permitted, and for which the BOCC had also just issued further approvals. So the overview of my presentation today, just going to talk through legal standards, to discuss a little bit the site and procedural history, although Director Case has already talked a little bit about that. Explain what the Court of Appeals decided in this and the application of the Court of Appeals opinion to the board's consideration now, and then walk through this board's factors on appeal, and finally end up with the discussion of why equitable considerations require that this board find that the director erred, including there was a lapse. So here's a standard of review for a land use interpretation of appeal. I'm sure you all are all familiar with this, and we'll talk through these standards in a minute. But I wanted to first give a little bit of background here. The lapse provision is, I think, expansive, and the county has interpreted it expansively. You see the underlined and bolded provision here that says if there has been no activity under any portion of the special use permits. And that's what was at issue in front of the Court of Appeals as well. But I think that this expansive language is consistent with what you see when you have discussions about property rights. For instance, if you're going to extinguish an easement, you can't just say it's gone because no one did anything with it for a while. The common law requires that you have to take some sort of affirmative action that's contrary to the easement. It's just unusual to have property rights disappear just on the basis of inactivity. And this provision is really expansive in what it requires. That SOSVB, the interested parties in this, need to demonstrate that there was no activity under any portion of the permit. Also, it has to be within the cause or within the control of the special use permittee or agent. That's an important factor here too, as we talk about what happens, particularly post 2013. So here's the site. We're on Highway 66 in St. Fran, or the St. Fran through here between Lyons and Longmont. This is an approximately 1,000 acre site. And as Director Case mentioned, mining has been going on here for since 1973. It's been a long-term operation, first under a collection of permits, and then more recently in the special use permit, it was consolidated for a 33-year mining history. Director Case walked through the site history a little bit. I do want to make one note though, because he'd suggested that mining hasn't occurred on this site for 15 years. But since 2017, this has been held up in litigation of one form or another, whether it's in the court or it's in front of Director Case, and the necessary approvals to go forward with any kind of mining on the site remain pending in front of Boulder County. Those applications are out there. Boulder County hasn't taken the existence of this appeal and the continued litigation. So since 2017, at least, it's just been impossible and certainly outside of Martin Marietta's control to do anything with respect to the site. It just remains held up. But what about the activity history? So from 1970s until 2006, mineral extraction certainly did occur on site. And then there was open mining again in 2015 following the catastrophic 2013 floods when Martin Marietta went out, conducted testing of the site, removed materials, analyzed those materials, also dewatered a pond and cut the rampway. So there was in fact mining that occurred out there. But more importantly, for this appeal, or perhaps most importantly for this appeal, there were a number of accessory uses authorized under the special use resolution. That resolution details quite a few different accessory uses, and all of those have occurred throughout the period that's in question here. So since the 1970s, outside storage and equipment maintenance, groundwater monitoring, an essential component of making sure that the mining operation can continue and doesn't have effects on groundwater levels. Stockpiling has occurred. The hauled materials away from the stockpiles has continued to occur as well. Again, throughout the period following 2006. The portable office too maintained out there until 2016, at which point Martin Marietta removed it with the expectation of replacing it. The low water crossing and conveyor bridge, again, expressly authorized accessory uses under the permits that was continued to be maintained, and the various facility upgrades more recently as well. All of these things are exactly what you would expect to see in a multi-decade mining operation, even if there's not mining activity occurring during this time. These are the sorts of things you would expect to see on a site to keep it in a place where it could be operational and can continue to operate, keeping buildings updated, keeping equipment on site. I simply don't know if a code enforcement officer had gone out there during that time. I think that you would have to say that all of those uses were occurring pursuant to some permit. Those are uses. And for instance, the Boulder County Code has outside storage as a particular accessory use. It's also I guess it has to be accessory, but these are all uses and would require some sort of authorization out there. This is a little flow chart of the sort of sordid history of all the various appeals and where we arrive or how we've gotten here today. But it's important to note, and we'll talk about this in the context of the equitable considerations as well, that the county's position all the way up through getting reversed by the Court of Appeals was that the special use permit remained valid, that it had not lapsed. The district court, the Boulder County District Court, agreed with that. Certainly that wasn't reversed at the Board of Adjustment level. Director's Case's initial interpretation was that the permit hadn't lapsed. Eric Heil, the outside land use attorney, had determined that the permit had not lapsed. Everyone, with the possible exception of the interested parties, had agreed that the permit hadn't lapsed up until the Court of Appeals said otherwise. What did the Court of Appeals say? We should be really clear about this because the intervener, or rather not the interveners, but the interested parties have suggested that the Court of Appeals didn't say anything at all about whether Director Case was supposed to consider accessory uses. And I think that the plain language of the Court of Appeals opinion belies that contention. The Court of Appeals discussed the meaning of special use permit and said that the director in the county had misunderstood the meaning of the special use permit, and it expressly states that it includes authorized accessory uses. So the special use permit under the lapse provision is instead the permitted special use and any accessory uses that may have been authorized. So the reason we're bringing up accessory uses now is because the Court of Appeals specifically told us to. This is not some sort of new idea that we're bringing in at a late hour. It's the Court of Appeals said that the Director Case ought to have the correct understanding of the special use permit, and that includes authorized accessory uses. So the law of the case, or the doctrine of the law of the case, applies to land use proceedings as well. We're on remand from the Court of Appeals. Certainly, Director Case couldn't take a position, even if Martin Marietta wanted him to, that was contrary to the Court of Appeals opinion. We're back here and the Court of Appeals provided direction. But the interpretation now has to comply with all of the various things that the Court of Appeals said. So when the Court of Appeals concluded that activity under any portion of the permit for the lapse provision includes any accessory uses that may have been authorized, well, then that's what the interpretation had to consider. That's what Director Case had to consider. And I think it's really important here to say, or to note, that the Court of Appeals concluded that there was no mining activity. The principal use was not occurring between 2006 and 2007. Yet nonetheless, it directed Director Case to look at accessory uses. So it simply can't be the case that the primary use or the principal use must be occurring for the accessory uses to matter. The Court of Appeals said, you get to look at both. Is one of those things occurring, or is the other occurring? So you're saying you just don't have to have a principal use operating at the same time, because what would it mean? It wouldn't mean anything at all if you had to have the primary use, because then the only question would be, is the primary use occurring? There'd be no reason to look at whether the accessory uses were occurring. And again, this makes sense for a multi-decade, 1,000+ acre operation where, sometimes you have interim periods where there are accessory uses occurring, but there might not be active mining on the site. So again, I had mentioned before all the various accessory uses that are authorized: outside storage of fuel oil and grease, repair of equipment, machinery, haul trips, all of these various things. These are expressly authorized under SUP 9618. When the Court of Appeals talks about are accessory uses occurring, it means these things. It also means implied accessory uses that would otherwise be allowed under the code. But these are specific ones. This is under a portion of the permit. A portion of the permit authorizes accessory uses. So first of all, the SUP hasn't lapsed because mining did occur. That open mining, which is the extraction of any earth and materials, that occurred in 2015. And it's our position that the only relevant lapse period is 2012 to 2017, because that's the 5 years before SOSVV requested a lapse determination. I think it would be silly to suggest that SOSVV could come in and say, well, we want a determination of whether the permit lapsed between 1973 and 1978. And we say, well, we don't have any information from that time. And they say, haha, it must have lapsed because you don't have information. There has to be some limit to the lapse period and the relevant period that's for consideration. And we think it's the 5 years before. So there was mining during that 5-year period. That alone prevents lapse. But then those authorized accessory uses all prevent lapse as well. All of those various things occurred: the outdoor storage of equipment, the maintenance of that equipment, the buildings out there, the groundwater monitoring, the stockpiling, the continuing to use those stockpiles, selling off materials, hauling them away during this period that's in question, the low water crossing, the portable office, the site upgrades. All of these various things are the authorized accessory uses under the permit. This is activity under any portion of the permit. So applying the appeal criteria, the technical meaning of the provision appealed, the technical meaning of the lapse provision, well, I'd submit to you that the Court of Appeals has given you the technical meaning of the lapse provision. And it is that any activity under, as the principal activity, the principal use, the special use, or the authorized accessory uses, and that includes any activity directly related to the principal use, or those authorized accessory uses. That's precisely what the Court of Appeals said. That's how Director Case needed to interpret that provision. And with that interpretation, that technical meaning, the site has remained in continuous use. And How about the past interpretation of the provision? Well, the county has taken an expansive interpretation of that provision for decades now, almost since that provision was adopted. First with Eldora Ski Resort saying, well, of course, you can have different phases of development. Just because you've done one structure and haven't done another doesn't mean that the permit lapses. That went to the Court of Appeals too. And then more recently, Director Case's initial interpretation was expansive, saying that reclamation was also a use that was included in there and that the conditions were also sufficient to prevent a lapse. So the county has consistently taken an expansive position, and it makes sense. You don't want to have a multi-decade operation just evaporate so quickly and so easily. So the principles of interpretation, Director Case's interpretation does conflict with the provision of law because it conflicts with the Court of Appeals opinion. So Martin Marietta's interpretation is the better one here under that criterion. And then the effect of the interpretation and the intent. I mean, the code speaks about maintaining agricultural and industrial opportunities, providing for the planning of mineral deposits. This was a plan. This was a 33-year plan to provide for that. This does not preserve access to aggregates, or rather, Director Case's interpretation doesn't preserve that access, but it does hinder the ability to extract it. So the criteria under the code all support Martin Marietta's position that this has not lapsed. This SUP has not lapsed. And finally, there's a question of equitable considerations as well. Certainly the county had mentioned in 2006 that the possibility of a lapse was out there. But as I mentioned before, the county's position has been up until reversed by the Court of Appeals that there was no lapse. And that the activity had sufficed to prevent a lapse. We maintain that that's still the case, but to promote fairness in land use proceedings, and certainly an experience that the county has had before with Eason and the Board of County Commissioners case too, it is the case that when county staff and county officials sort of consistently say, let's go through the process, you're going to get a permit, ultimately bring the applicant in front of the Board of County Commissioners where they get approvals, that there are equitable considerations here. No one had suggested until SOSVB arrived that there was any potential for a lapse. And it was in reliance on the county's action that Martin Marietta spent more than $1 million putting together its materials to update the site plan and to move various components around on this and prepare for operations. So again, you see the timeline here on all of this, but the takeaway is that county staff had consistently offered Martin Marietta the opportunity to come through and go through this approval process all the way through the BOCC, and no one, the other folks had showed up, contested that. So for these reasons, we respectfully request that you reverse the decision. Thank you very much, and I'd be happy to take your questions.
Thank you, Mr. Peters. And if you want to continue past the 15 minutes, that would be fine. Or are you done?
Oh, as it happens, we arrived on the last slide right now. So that's where I needed to stop. So thank you very much.
Okay, thank you. I'll now open it up to questions from board members. Hearing none from my fellow board members, I have a few questions. You would agree that a reasonable company should know that decisions by the county's planning department can be appealed to a court, correct?
I suppose it depends on so yes, in general, there are options for appeals. Whether a particular decision is eligible for appeal or not, I suppose depends on the decision itself.
Mm-hmm. Well, was Martin Marietta aware that a lapse determination can be appealed to a court?
Honestly, I don't know what Martin Marietta knew at one point or another. I mean, I think that the code I'm not sure what the code said in 2017 or 2012 or at that point, but I would imagine that it said that there's a possibility of an appeal to the BOA that would then subsequently be appealable via Rule 106 to a court. Whether Martin Marietta was aware of that or not, I'm not sure because I wasn't counsel then.
Thank you. And in terms of the outside storage, did you, during your testimony, claim that the material that is being outside stored has been sold?
It was hauled away. My assumption is that it was hauled away as it was sold in that period. It's possible it was hauled to a different site, but what's in the declaration of Ms. Mikulus is that there was material stockpiled on the site and that Martin Marietta continued to haul that material away. So I will stick with what her declaration says, but my assumption is that it was sold.
But you're saying there's no evidence that it was sold. That's just an assumption of counsel.
That's correct. I believe her declaration says that it was hauled away from the site.
Mm-hmm. Where was it hauled to?
That I don't.
When was it hauled?
This was in a period following 2006. So there remains a stockpile on the site even today. There's one stockpile remaining, but the stockpiles have consistently been drawn down or have been drawn down.
So post 2006, but do you have any evidence that any of the material was hauled away in 2017 or later?
I don't know whether anything was hauled away in 2017 or later. Her declaration says that I think as of 2017, and maybe even as of today, there remains some of that. It's our position, at least with respect to 2017 and later, that it's impossible to conduct any sort of mining activity at the site because of the lack of approvals.
And so is it also impossible to haul material away that's been stored there?
I don't think that it's impossible to haul away material that's been stored there, but the storage of the material itself and the stockpiling of the material itself continues to be an accessory use that's authorized under the special use permit. So whether it's hauled or not, the hauling is an accessory use and the stockpiling is also an authorized accessory use. And those accessory uses continue, all the ones that I was telling you about. And the office, I believe, was removed in 2016, but the equipment storage, in fact, more equipment was brought on site in 2016 and 2017 in preparation for the additional mining operations contemplated under the approval that Martin Marietta had gotten.
And so it would be your position that if Martin Marietta had material sitting there for 100 years, that would still constitute storage?
Yes, I don't think we're presented with a 100-year scenario, but the stockpiling, if the materials were continued to be stockpiling there, and certainly we have a situation that's not just materials were stockpiled there. We have the equipment maintained. We have everything remains in a state of readiness and continued maintenance out there for is stockpiling out there. But if you think about, say, a non-conforming use and a lapse of a non-conforming use, for instance, if there's an abandonment of the use or there's no maintenance that's occurring, I think that's a different situation than where there are continued operations out on the site and there's continuing maintenance to keep things in good repair. Folks are going out there and monitoring groundwater, all of those various activities. This is not a site that somebody just mothballed, didn't do anything. So there's quite a bit more activity than just leaving a pile.
Okay, thank you. I have no further questions.
Thank you.
Okay, so next up, we'll have the presentation from the city of St. Vrain Valley. And Mr. Peters, if you could stop or unshare your screen. Thank you.
Can everyone see that?
Yes, thank you.
Thank you all. James Silvestro. My business address is 717 17th Street, Denver, Colorado. I'm here tonight on behalf of Save Our St. Vrain as their land use council. Before I begin, I do want to thank staff as well as commissioners for your time and consideration of this very important matter. So just briefly, some of you probably know Save Our St. Vrain Valley is a grassroots nonprofit that's dedicated to preserving and conserving the natural environment in the St. Vrain Valley. We've got a picture here on the slide from the Daily Camera article after we won in front of the Court of Appeals with some of the Save Our St. Vrain members shown there. I think both the applicant and Director Case did a good job of going through the history, but it is important to remember that while this administrative proceeding began back in 2017, what we're actually talking about tonight, the lapse, that began back in 2006 when Martin Marietta's predecessor in interest, Lafarge, voluntarily decided to stop mining this site. And so everything that's happened from then until now, this 16 years of non-use, flowed from that. It flowed from that initial decision to stop mining at this site. And I want to just briefly respond to something opposing counsel said. What we're talking about tonight is not an easement. We're not talking about a use by right. We're not even talking about a vested right. We're talking about a special use permit, which is a special license. It's something special permission, not something that everybody gets. And so I think it's perfectly reasonable that Boulder County attaches certain conditions of approval, as well as certain rules regarding the abandonment of that special use. And as we'll get to towards the end of my presentation, the reason that the county does that is to protect surrounding land users, because when you have a special use permit, you are entitled to something special to engage in a more intensive land use than is otherwise allowed at the underlying zoning. Here we're talking about a site that's really just zoned for agricultural use. But again, going back to the timeline, in 2006, Lafarge stopped mining and they started filing annual reports with the State Department of Reclamation and Mining saying there's been no mining in 2007, no mining in 2008. If you actually move forward to 2011, when Martin Marietta bought this permit, Lafarge, just before selling it, actually put the state mining permit into administrative cessation. So when Martin Marietta blames Save Our St. Vrain for the fact that they haven't been able to mine for the last 5 years, part of that is because their permits lapsed, but it's also not clear to anyone, there's no evidence in the record that they actually have an active DRMS permit to mine at this site. So I think that's important context as well. And then ultimately, I think it's clear sort of how we got here within this proceeding where we had a majority of this board actually side with SOSVV back in 2018 to find that this permit had lapsed. Unfortunately, that was one vote short of the necessary supermajority. And so we had to go to the Court of Appeals to ultimately get the initial decision reversed. I'd also take issue with opposing counsel's suggestion that because the county previously found that the permit had not lapsed, that somehow that in equity or somehow, I don't really understand the argument, that could somehow nullify the Court of Appeals decision here and ultimately Director Case's decision on remand. So turning to the two issues that staff has specifically teed up, neither of which provide a basis for reversing Director Case's revised decision. The first is that there still has been no activity under any portion of the permit. And that's how the 5-year lapse provision applies here. And then second, there's no equitable basis to revive the lapse permit. And there's sort of sub issues under each heading. And frankly, any one of these sub issues, which I'll walk through now, would be a basis for affirming Director Case's determination that this permit has lapsed. So starting with that first issue, and this is actually a point where we disagree with Director Case and obviously opposing counsel. But if you actually look at the Court of Appeals decision, it's very clear that the remand order back to the county flows only from this point, starting however, where the court says, well, you know, obviously there's been no mining here. There's been no special use activity. The lapse provision has caused this permit to lapse. There was this other consideration, this equitable argument that Eric Heil had considered, which Director Case decided he didn't need to get to. And so the Court of Appeals has remanded solely for the county's consideration of those equitable factors. So I think right out of the gate, the Board of Adjustment and Director Case, frankly, can take the fact that Martin Marietta previously stipulated, that's in the Court of Appeals decision, it's paragraph 9, they stipulated that no mining activity has occurred at this site since 2006. Their whole argument was about actions that they took under the conditions of approval. And so on the first issue, this can really be the beginning and the end of it, because the sole question on remand is whether equitable estoppel would work to resurrect this permit, not whether the permit had not lapsed. Everybody already knows that the permit has lapsed. Sort of the natural outgrowth of that is the fact that Martin Marietta also has not been given a second bite at the apple, even though they're trying to take one. We've got all this new evidence that they're trying to present into an administrative proceeding that's been ongoing for 5 years. They've waived any arguments that are now put before this board for the very first time. And that includes the 57 paragraph declaration from one of their employees, which is all new information. And it also includes the 360 pages of new information that they've tried to put into the administrative record. Their chance to show that the permit had not lapsed was back in 2018. That administrative record has been closed throughout this whole time. The only instructions that the Court of Appeals gave to Director Case was to revisit his decision in light of the Court of Appeals decision. It was not an invitation for Martin Marietta to completely try to push new theories and new evidence that was never previously presented. So again, I think the board can ignore all of that and close this down pretty quickly. But even if the board does consider the new evidence that Martin Marietta has put forward, there's 3 reasons why I think, you know, they're really focused on this 2015 testing, which again, we never heard anything about in 2017 or 2018. There's 3 reasons why that testing is insufficient to have prevented a lapse. The very first is that Martin Marietta itself previously stipulated that there was no mining activity since 2006. And again, in paragraph 9 of the Court of Appeals decision, that was confirmed, the law of the case, by the Court of Appeals. The second issue is that to the extent that that testing was done to plan for new mining, the Court of Appeals in its decision expressly rejected Director Case's previous determination that planning and reclamation activities under the permit would prevent a lapse. So again, those sorts of planning activities are not the sort of thing that could keep an unused permit open indefinitely. And then finally, as Director Case noted, alleged activities that occurred in 2015 are irrelevant because the fact that mining stopped in 2006 means that the permit necessarily elapsed in 2011. And contrary to opposing counsel's suggestion, we're not talking about some period in the 70s. We're talking about 2006 to 2011 when they previously stipulated that no mining had occurred. Another point I'd make on that too is that the 5-year lapse provision doesn't talk about the preceding 5 years. It talks about any continuous 5-year period of non-use. And then I do also want to address the focus of Martin Marietta on these accessory uses. There's a number of reasons why the alleged accessory uses are also insufficient to have prevented the permit from lapsing. The first is that by definition, an accessory use cannot proceed and operate independently of the principal use. If that were the case, then anyone could engage in illegal land uses that they could say, well, they're tangentially related to planned legal uses that we intend to do in the future, or that maybe we did 10 years ago. Obviously, that's not how accessory uses function. The second point is that an accessory use is by definition not something that's otherwise allowed by right. So I'm not aware of anything that prevented them from storing rocks at the site, or, you know, obviously they had a site plan approval to build these buildings going back decades. But the fact that they sat there abandoned and unused doesn't change the fact that there was no activity under this permit. Another point, and this specifically relates to the groundwater monitoring, which is a condition of approval under the permit. The Court of Appeals specifically considered and rejected the notion that those activities that were taken merely to satisfy conditions of approval do not constitute activities under the special use permit. Similarly, and as I just mentioned, the Court of Appeals also rejected the suggestion that pre or post mining activities could prevent the permit from lapsing. So they talk about, you know, not wanting to shut down this decades old use. This use has not been engaged in since 2006. And, you know, I think I disagree with opposing counsel. I think this use very much was mothballed. Maybe they had someone drive by once or twice a year to make sure, you know, the fence hadn't fallen over. But for all intents and purposes, there was no indication to the neighbors, to the county, to anyone else that any active mining was happening here, because it wasn't. And then finally, I think this is a really important point, because they spent so much of their written submission focusing in on the pictures of rusted equipment and this pile of rocks that apparently has been sitting there for no one knows how long. Even if a use was approved as an accessory use under the special use permit, the 5-year lapse provision still requires activity. And so the fact that there are empty buildings there, and there's rusted equipment, and there's an old bridge, and there's rocks that, you know, maybe they've been slowly picked away at, but there's not actually any evidence of when that happened. None of those accessory uses are activities that would have prevented this permit from lapsing. So then I do want to turn to the second issue, which is the equitable estoppel issue that I respectfully would submit to you is actually the only issue on remand before the county. Curiously, the Martin Marietta didn't actually decide to appeal this portion of Director Case's decision. Obviously, we just heard them discussing it, but the county's appellate rules for bringing an issue to the Board of Adjustment requires a statement of the interpretation being appealed be submitted to this board within 30 days. Their written submission is all about the fact that they are now claiming, contrary to the earlier stipulation, that they've engaged in various mining activities and accessory uses over the years. None of that written submission actually relates to these equitable arguments they're now trying to revive. And so again, I think you could find that that issue has been waived as well. But even if you do get to the substance of this issue, I think there's two really important points, one of which Director Case touched on, which is that the county itself never actually made a determination that the permit had not lapsed. So to the extent that Martin Marietta wanted to rely on the fact that the county hadn't said anything, that was not reasonable. In 2006, their predecessors was expressly warned about this issue. The no zoning violation letter in 2011 didn't say anything about the lapse provision or whether or not the special use permit was still valid. Ironically, if they had tried to engage in mining in 2012, that would have been a violation of the zoning code because, as we all know now, their special use permit had lapsed. But because they let it sit dormant for another 5 years, no one ever actually had a reason to call them on that. And then similarly, the 2017 administrative approval, that was done through a non-public process, and it wasn't until the final plat approval or the modified site plan approval where that actually became public in front of the Board of County Commissioners, and members of SOSVB discovered that Martin Marietta, for the very first time, was seeking to restart mining operations. That's what caused members of Save Our St. Vrain to question the lapse of the permit, and ultimately that's how we got here today. There are a few other points that I think are worth highlighting within the lapse permit itself. Under condition 7 of the lapse permit, Martin Marietta was required to complete a 5-year interim review every 5 years under the permit, and that never happened. Of course, the irony of that is if they had engaged in a 5-year review in 2012 or 2014, 2016, then they actually would have been, I think the county would have pointed out, hey, if there's been no mining here since 2006, this permit's lapsed. So instead, they just failed to comply with that condition of approval. Again, when we talk about equity, I think you have to consider fairness. This is a result that Martin Marietta and its predecessor brought upon itself by, one, deciding voluntarily to stop mining in 2006, mothballing their state permit in 2011. And then, as you see here, failing to seek any kind of interim review that might have called this issue to the forefront earlier. The other thing that I'd point out about the special use permit that's also under condition 7 is that before they can engage in the new phase of mining that they're now looking to begin, they have to get a 5-year pre-approval from the county. They have not begun that process. And so even if you were to reverse director case and find the special use permit is still in effect today, the soonest they could get through that 5-year pre-approval would allow for mining in late 2027, probably 2028. And that's really important because condition 1 of the approval says that this special use permit must stop by the end of 2032. And so really all we're talking about at this point is 4 years of mining that they're trying to get under this old abandoned permit. And I think that sort of begs the question is why are they fighting so hard to preserve these 4 years of mining? And if you think about it, the answer is pretty obvious, which is that the conditions at this site and the conditions within the county changed. They know that if they were to seek a new special use permit today for mining at this site, it's very unlikely that the county would approve of it. And that really speaks to 2 issues. One, speaks to the purpose of the 5-year lapse provision. A party shouldn't be able to sit on its right for years and years, decades, and then ultimately just, resume the special use without any kind of public input or review. And it also speaks to the equities of the situation. Again, they know that it's very unlikely the county would approve this use in 2022. But ultimately, the unfairness there is to the surrounding neighbors who have invested in their land and relied upon the fact that this has been an agricultural dormant site for going on 16 years now without any notice that one day they could bring in the backhoes and the big trucks and start mining again. The other thing that a new review would consider is all of the changed circumstances at the site. I'm a little short on time here, but I think it's important for the county to consider the acceleration of climate change. We see the impact of the 2013 flood here on this slide. Obviously, the population has increased all throughout this area. And again, if you're going to consider the equities, you have to consider all of the equities, including the public interest here. So for all of those reasons, we'd ask that you do not reverse director cases revised decision. Thank you. Sorry, I ran a little bit long, but happy to answer any questions.
Thank you. I'll open it up to any board questions. Hearing none, we'll move on to.
Sorry, Mr. Kiley, I actually did have a question. I was wondering if I may ask it.
Eric, I don't think he understood you. You're requesting permission.
Sorry. Yeah, Mr. Kiley, may I have permission to ask a question?
Certainly.
Thank you. Mr. Silvestro, one of the things that I'd like to hear a little bit more about is how conditions may have changed at the site and your view on how that affects our analysis of this issue. Now, you got cut off, and I'd like to give you a chance to kind of finish that analysis for us briefly.
Sure. I think really the issue there is that if the board is going to consider equitable considerations, and there's, the case law, I'm not aware of anything that says you have to do that you could overrule the 5-year lapse provision and sort of resurrect a lapsed permit. But if you were to consider that, I'm humbly suggesting that you have to consider the equities on all sides. And so again, to the extent that neighbors, surrounding landowners, business owners, the fact that folks have invested in their properties in reliance on the fact that there's been no apparent notice of this special use because it hasn't been active. It's been a chain link fence, along the creek. My point there is that, to the extent that all of these folks have come to rely upon that's an equitable consideration that the board should consider as well. And really what we're talking about when you have a lapsed permit, when you have such a continuous period of non-use, is that the code compels the termination of that special use permit And Martin Marietta is free. They were free in 2017. I mean, they complain about the 5 years they've been held up. They could have applied for a new special use permit in 2017. They could have said, whoops, Lafarge sort of misled us, or we got confused, whatever the argument is. Let's just start fresh. Let's get a new permit. There's a very obvious reason why they have not done that. And that's because they frankly do not want the Board of County Commissioners to have the ability to look at whether or not this use is appropriate at this site in the year 2022.
All right. Thank you. That was my only question.
Thank you. Any other questions from board members? Seeing none, we can now move on to hearing from the public. And if staff wouldn't mind going through the list of folks that from the public that want to comment.
This is Anna Milner's staff. I'd like to note that we believe the technical issue that Director Case described earlier has been resolved. So we'll proceed to promote each member of the public to be a panelist to speak so that you can then speak and show your video. First, we have Bart and Sarah Lorang, and I will be promoting you shortly. Note you'll receive a pop-up indicating that you need to select join as panelist for that process to be successful. So just give me one moment and I'll proceed to promote all of the public speakers.
Hi, can you hear me okay? Yes?
We can, Sarah. Thank you.
Sorry. Sorry. Okay. Hi, my name is Sarah Lorang and my address is 12800 Foothills Highway. First, I just want to take a moment to commend Dale Case on his decision that the 5-year lapse provision should have been applied to Martin Marietta's special use permit and that the permit has indeed expired. I recognize how difficult it is to change your position on something in a public setting like this. So I just wanted to first say thank you to Mr. Case for doing the right thing as more information and insight came to light with this intensive special use permit. Second, I just want to reiterate how important I believe it is to enforce the policies we create. With elections right around the corner, I'm sure we will all vote on various hotly contested ballot items for new rules to be established within our communities. We put so much thought and effort into creating these policies and getting them enacted into law, as the spirit behind them is usually to protect our better our community in some way. The 5-year lapse provision, Land Use Article 4.604C, is not any different. The spirit of the lapse provision was to protect the surrounding area from exactly what Martin Marietta would like to do. The area around Martin Marietta's intended mining site has changed a lot in 20 plus years, and whatever logic or research cited to support that special use permit back then obviously isn't reflective of conditions today. A new application needs to be submitted so that impacts can be assessed using current conditions as a baseline. The Boulder County Commissioner's recent denial of special use permit 220003 for an extension of mining at Dow Flats further supports that these intensive special uses must be compared to the community they lie within today, not what they looked like more than 20 years ago. Again, that was the spirit of the lapse provision in the first place, to protect a developing and changing community. We're just asking you to enforce this policy that was thoughtfully put into our land use code for very important reasons. Because why do we have any rules at all if we aren't going to enforce them? Semi-related, Mr. Peter said tonight that property rights can't just be extinguished because of inactivity, which feels misleading at best because we're obviously not talking about property rights here. This was a special use permit for an extremely intensive mining operation, which I would argue is a privilege granted by the county, not a right as a property owner. And as anyone with kids can attest to, there are always strings attached to privileges. I'll spare you all the reasons why Martin Marietta's claims that they were actually using their permit aren't valid, because I can see that you are logical and intelligent people and know what generally constitutes mining activity and what does not. And as James Silvestro has previously argued, the context of the word activity in the lapse provision matters. So Martin Marietta must prove that they have done activities specific to the privileges granted in their special use permit, which they have objectively not done. In conclusion, I'm asking that you uphold Director Case's decision that the 5-year lapse provision should have been applied to Martin Marietta's special use permit and affirm that permit SU 9618 has indeed expired. Thank you for your time.
Thank you.
This is Anna Milner's staff. Sarah, can you please confirm that Bart is not speaking, or will Bart be speaking today?
He will not be speaking tonight. I'm sorry.
No worries. Thank you. Next, we have Wendy Kahn, but I'm not seeing that Wendy is actually in the meeting, so we can move forward to Wiley Hobbs.
Hi, can you all hear me? Hello?
Yes.
Hi, my name is Wiley Hobbs. I live at 11683 Point View Drive, right off 36. So I don't really think I need to say much. I mean, I think you all know what the right decision is, both legally and morally. If you don't, I mean, it's really just to uphold the decision the Court of Appeals made and the recommendation of Director Case, which is to reject this appeal. I think we all heard Mr. Peters, or maybe, I mean, he certainly spoke a lot, but, you know, I think he doesn't have much to stand on. His presentation was rushed. I think it was generally rife with speculation, as was pointed out by the chair. And I think it genuinely lacked conviction. I mean, he's being paid to do this and could likely really care less what happens. It's just a minor assignment to him. He has no connection to the land. It's pronounced Saint Vrain. He mentioned the situation was unusual, but what I find is unusual is that he documented that the 2015 mining activity was not unusual, despite the fact that it was for a rare flood event. That, you know, what do we call it, 100-year flood or something? So, I mean, the speculation continued during the questioning. He was not counsel previously, does not seem to know the case very well, yet you all need to trust what he's saying is true and accurate. You know, I'm not being paid. I live in the area. I value the land. I value the wildlife. I value the people. I value the air. That's my motivation. Also, my dog chewing on his toy over there is my motivation to keep him healthy, to keep my unborn children healthy. He's, you know, counselor's trying to add confusion or notice the situation, but honestly, it's dead simple. All you have to do is uphold the Court of Appeals ruling. So I was actually just at the area last night and was fortunate enough to encounter 4 eagles in the area, which is pretty incredible. If you've ever been out around Hygiene Road or even up at Rabbit Mountain, you might have seen these eagles. I think we all know that if mining activities were to happen, these eagles would die or they would be forced to leave. And we already know that bald eagles are protected under several endangered species acts. They're no longer critically endangered, but we don't know what will happen should we disrupt their habitat. I'm sure we'd have to consult these acts either at a local or federal level. I'm not sure it'd be a very easy thing to do. So I would like to add that to consideration, as well as demanding a full environmental impact study along with this. And the bottom line is we don't need more mining in the St. Vrain Valley. The ecology is too important. The water supply is too critical to a growing population. The air quality is degrading every day. Are you prepared to live with the ramifications of the decision today? So I highly recommend you just reject this appeal. Thank you.
Thank you.
Next, we have Molly Hardman.
Hi, my name is Molly Hardman. I live in just down the road from Wiley at 11676 Point View Drive in unincorporated Boulder County. I don't have a lot to say. You know, I'm a scientist, so I'm not very good at lawyer speak, although I did appreciate hearing both sides of it. But I just would recommend that the Board of Adjusters uphold Director Case's decision. It seems straightforward and obvious to me that we should follow what the Court of Appeals decided. And we also want Boulder County to consistently uphold their regulations, their rules. And even more than that, you know, I'm an old person, you can see that. I want to protect the unborn children of Boulder County. I happen to be a climate scientist, although I'm not speaking on behalf of my employer. And we need to do whatever we can to protect and take account of our environment and allow future generations to enjoy this area. I may not be speaking very, you know, as coherently as the lawyers, but I urge you to reject this appeal. It makes no sense. And the idea that, you know, piles of rocks and things like that constitute activity. And especially I appreciate the comments of Sarah about the extraordinary nature of the 2013 flood, which I lived through with, you know, all the loss that came with it. I think you ought to do the right thing, support Director Case, and reject this appeal. Thanks very much.
Thank you.
I don't need my full time. Thank you.
Next, we have Hunter Levens.
My name is Hunter Lovins. I live at 5150 St. Vrain Road in unincorporated Boulder County. I'm an internationally recognized expert on climate and environmental protection, author of 16 books on the topic. I beg you to reject this appeal. Martin Marietta failed to meet the threshold for finding that the county should overturn the determination that the permit to mine has expired. No mining has occurred for 15 years, nor should it. In 1973, when the permit first issued, Boulder was a very different place. Mining and industrial activities were an acceptable use at that time. 50 years later, Boulder is different. Mining has no place in a residential community. This is why we have land use laws. The world is a different place. We are in a global climate crisis. This was brought home to us here by the Marshall Fire last December. The destruction last week of the coast of Florida is just the latest evidence of the climate chaos we're in. If this activity were to go forward, the additional truck traffic, the additional mining activity are all sources of emissions that we cannot afford. Boulder County has committed itself to cutting emissions, committed itself to creating a sustainable community. Allowing this to go forward would violate those commitments. Martin Marietta has not maintained the needed permits to engage in the mining under the special use permit. Their state mining permit, which it must have to mine, has been in temporary cessation since 2011, which is to say they're not mining there. Director Case has admirably reconsidered his original position, realized that the activity is no longer permitted, and he had the intellectual courage to put forth the position that you heard him say tonight, which is in service to the people of Boulder County. Director Case is upholding the land use codes and the policies that were put in place for the purpose of protecting our community. Please support Director Case's recommendation and deny this extension of an extremely environmentally destructive activity in the middle of a residential community. Thank you so much for your consideration, and I cede the rest of my time.
Thank you.
Next, we have Dana Bove.
Hello, this is Dana Bovey. I live in at 1935 Tin Cup Court in Boulder County, and in Boulder, and I represent Front Range Nesting Bald Eagle Studies. We have spent quite a bit of time thousands and thousands of hours out in the hygiene area where they wish to mine over the last, since 2014, 2015. Anyway, while this hearing's largely about the technicalities of whether this permit is lapsed, which it clearly has, our organization, Front Range Eagle Studies, would like to remind this board about what underlying is at stake here. The 800 acres of open space land that Martin Marietta wishes to mine supports one of the richest, if not the richest areas in Boulder County, supporting at least 3 of the county's listed raptor species of special concern. These include golden eagles, ferruginous hawks, and bald eagles. Since 2010, a pair of federally protected bald eagles nest within the proposed mine area. These territorial eagles intensively use and are sustained within a territorial space of 3 square kilometers. This territorial area is roughly equivalent to 92.5% of the area that Martin Marietta proposes to mine. Our long-term studies document that these bald eagles obtain a minimum of 45.4% of their prey in the same nearly 800 acres that Martin Marietta wishes to mine. These 800 acres support one of the richest and healthiest prairie dog communities in the Northern Front Range. It contains 0.39 square kilometers of prairie dog colonies, which we've mapped, which comprises 13.5% of these nesting bald eagles' territory of 3 square kilometers. The territorial bald eagles spend at least 50% of their time in this territory 12 months out of the year. And that's the minimum amount of time that they're there. Throughout much of the year, this rich prairie dog habitat brings 1 to 4 golden eagles, a key species of special concern, on any given day. In addition, from fall through winter, another, over the last number of years, a ferruginous hawk, another county species of special concern, winters in the same territory with the territorial bald eagles. The ferruginous hawk's main source of prey, prairie dogs. Many of the territorial or non-territorial ferruginous hawks also use this area through the winter into spring, as do a rich abundance of other raptors, including prairie falcons, northern harriers, peregrine falcons. They all use these same 800 acres with great frequency. All these raptor species converge in this area due to the rich prey habitat. What's at stake here, I'm finishing, is that with 100% certainty, Martin Marietta's mining here would destroy this special habitat for all these species. Please reject this appeal, and thank you very much for taking my comments.
Thank you.
Next on the list is Victoria Simonson.
Hello, this is Victoria Simonson, the town administrator for the town of Lyons. And on behalf of Mayor Rogan and the Lyons Board of Trustees, I want to share that they unanimously agree determination should stand. Specifically that the lapse provision should have been applied and Martin Marietta's special use permit has expired. Thank you.
Thank you. Can you please state your address for the record?
Absolutely. Town of Lyons, 432 5th Avenue, Lyons, Colorado.
Thank you.
Next, we have Lily Trenans. Lily, unfortunately, I have attempted to promote you several times and have not been successful. So I'm going to try again. If you can please look for a pop-up that will ask you to join as panelist. You'll have to click the join as panelist button to be promoted. So I'll give that a try right now.
Hi, sorry about that. Can you see and hear me?
We can, thank you.
Excellent. I'm Lily Trenans. I reside at 1336 Steamboat Valley Road in Lyons in unincorporated Boulder County, and have been a part of SOSVV since 2017, and was here for the first BOA meeting, in which I agree with the majority of the BOA members at that time, and particularly the statements by Commissioner Moots at that time that this clearly does not constitute a special use, that they had a special use permit and the conditions were not met. And so urge you to reject the proposal and agree with Dale Case's new determination that this does not constitute mining activities under a special use permit, and is just a continuation of the industrialization of the St. Vrain Valley, which we fully reject in terms of the ecological consequences, in terms of the artifacts that exist in this valley, and the residents and community that reside here. And I cede my time. I don't know if Amanda Domenico has arrived, but cede the rest of my time to her.
This is Anna Milner's staff. I've been notified that Amanda would like to speak, but unfortunately I am not seeing her listed in the list of attendees for promotion. So if we would like to give her another second to dial in, we can do so. Chair Kylie.
Yes, let's give her a second. Thank you.
Sure, Kylie, perhaps we should take a 5-minute break and then we'll come back to it, and hopefully Amanda will be on the phone or on the video.
That sounds good. Do we need motion for a break or?
No, it's just the chair's discretion.
Okay, thank you. All right, so it's 5:43. We'll resume at 5:48. Thanks, everybody. if the board members can turn on their cameras so we know you're back, that would be helpful.
Robert, this is Bill Walters. I can't get the video to turn on.
Okay, well, is it okay with you? We proceed with you on audio. There you go.
Chair Kylie, this is Anna Milner's staff. I am still trying to resolve. Okay, there we are. So just bear with me one moment. So Amanda, I saw your chat. You used Lily's login, so it looks like there are several Lilies. So I'm promoting Lily, and hopefully that's the right Lily to speak to this today. And then I'll change your name. So bear with me. You'll have to click join as panelist for that to be successful. I'll just promote all of these Lilies here. Bear with me one moment. This is Anna Milner staff. So I have requested all of the usernames Lily Treenans to be promoted. You will have to confirm that promotion on your end, Amanda and others.
I have confirmed it.
Great. And just one other note, we don't have the ability to manage seated time. In the public hearing guidelines, people have 3 minutes each, or the ability to pool time. And I do see Richard Cargill present, Amanda, so I believe we're all set to go for you to pool time with him.
Thank you, Anna. I also want to thank the Board of Volunteers. This is the second time we are meeting, and I realize that there are some new members. I thank you for your volunteerism. My name is Amanda Domenico, and I am one of the founders of Save Our St. Vrain Valley, and I serve as the executive director. I also want to take a moment to thank Director Case for his courage. I know multiple people have highlighted that, but it's important to know that it takes great wisdom to realize that they erred, and to admit it in this kind of public setting, and by so doing preserve over 800 acres in the St. Vrain Valley, which is the least developed river valley in the Front Range, or in 10,000 miles. I feel a little bit, I don't know that I will need my seated time, because I feel that everything has been said. The new information I ask that you don't review. This has been all the way to the Colorado Supreme Court, and as James Silvestro, our attorney, raised the issue of equity applies to the community as well, not to mention the land use code and the mission of Boulder County's land use code, which is to protect the citizens of Boulder County and the wildlife. I want to address something that was raised by opposing counsel regarding what has been done by the community. That Martin Marietta could have initiated the 5-year interim review, and they did not. We were not notified of the site plan hearing, as would be customary if it were to kickstart a dormant permit from last century, or from 1998. Julie McCoulis, I believe, reached out once, and they were also supposed to create a community advisory. And we were told that we would be hearing back in 3 months. We haven't heard about that in over 5 years. So the question of equity also applies to all of our volunteers, the wonderful people that you've heard speak today. They are affected. Their health is affected. Their property values are affected by 30%, I believe, in fact. So the Boulder County, I know that you've had great experts speak, like Hunter Lovins, a world-renowned, that advised the UN and others of that caliber. But beyond that, the Boulder County Commissioners have signed the EPA petition to reduce carbon emissions. They have also made a commitment to reduce CO2 emissions by 2030 by half. This project would certainly go against both of those things. And recently they have ruled to uphold the expiration of CEMEX's mining at Dow Flats in the area. So I do believe that that is why Martin Marietta has not applied for a new permit, and we're all experiencing this repetitive nature of going over. The permitted use was mining. The permitted use was not gravel mining or trucking trucks, and living across from the project, most of the project area has not been disturbed, and I am a personal witness to that fact. The raising of the accessory uses do not constitute permitted use, and that has been reviewed all the way up to the Supreme Court after Martin Marietta's appeal of the Colorado Appeals Court. We're not presented here with a 100-year scenario. We're in agreement there. You're presented with 4 years left of mining, and I don't see how it would even be feasible to cram the use into it. To even pretend that that would be feasible just on a realistic note. And finally, I just want to say, Save Our St. Vrain Valley came in exactly, we found it in March of 2017. At that time, again, they had just pulled this permit out of cessation, which had been in cessation with the state since 2011. So it's uncontested. It's verified in submissions annually by the operator for the last 20 years, which we provided ourselves for review by land use. And Director Case took many months to pour through the information as well. And it wasn't a clear-cut decision initially, but that is what has been clarified. The county had also never upheld the expiration of any special use, which are more intensive by nature. So I think Boulder County is in a great upward trend to actually be congruent with its mission and to actually uphold the expiration of special uses. And even if they just do that, it's clear that it will be a tremendous benefit during this climate crisis and during these fires and evacuations and everything that we're all living through to tip the scale in the right direction. Thank you for your time and your consideration.
Thank you. Can you state your address for the record, please?
Sure. 5625 St. Vrain Road, 80503.
Thanks.
Next, we have Kathleen Sands. Kathleen, you've been promoted.
How long was that? Thank
Can you hear me? Can you hear me?
you. Do you want me to take it, Dad?
Can you hear me? Can you hear me?
Yes, Kathleen, we can. Thank you.
So I just wanted to briefly say that I recommend upholding Dale Case's opinion that Martin's special use permit has lapsed. I've lately been looking at the valley and researching
I don't know why they can still
the
see.
mining in the area, and have spoken with my friend, Dr. Gordon McCurry, who's a hydrologist, and has discussed the detriment of water during mining operations. The digging, as he explained to me, does bring groundwater to the surface and creates little lakes, which is happening nearby. And this causes water depletion for the neighbors, for the local farms, for the local wells, and the local households. And so water depletion is a huge issue with aggregate mining like this, as well as likely flooding. He said, excuse me, I meant that there's likely contamination with flooding, which I'm not a water hydrologist, so I can't explain that further, but he has done a report for us for that area with that kind of mining and industry and how it does do that. So I recommend for these reasons to uphold Dale Case's opinion that Martin's special use permit has lapsed to preserve the water and the integrity of the land, as well as the incongruency of large aggregate industry in a farming agricultural small town like Hygiene.
Thank you.
Chair Ukaili, this is Anna Milner's staff. I don't see that anyone is remaining on our list. If you would like to speak, now is the opportunity to enter your name and address in the chat to let us know, or raise your hand. Thank you.
Okay, hearing no further members of the public, I'd like to open it up for board members if they have any final questions for staff, the applicant, or the other speakers. Oh, sorry, Anna, does Wendy Kahn Robeson want to talk?
It appears that she does, and I'm not seeing Wendy's name in the list, but I assume it's appearing as Lily. So let's just promote again. And Wendy, you can speak whenever you're ready. You'll have to click join as panelist.
Board member Scott Rudge, is that the name and the address of the previous speaker? Because I believe in the chat they said Kathleen is someone else, but she would like to speak. And I don't believe that previous speaker ever gave her name or address.
I believe that was Kathleen Sands. I'm re-promoting you, Kathleen. If you could please just confirm for the record your name and address.
Of course, I'm sorry about that. I am Kathleen Sands at 1960 Collard Lane, Lyons, Colorado.
Thank you, Kathleen. Wendy, I believe you've now been promoted as if you could please just state your name and address for the record. Wendy, I see that you're now promoted under the name Lily Treenans.
Had to unmute. Thank you. Wendy Kahn Robson. I live at 6152 Hygiene Road, Longmont 80503. And I just have a couple of sentences to add to the mix. I am a 30+ year realtor in Boulder County. The effects of gravel mining in this location would be devastating to the real estate values in the neighborhood. We've lived in our home since right before this whole issue reared its ugly head, and this was not something that I had any idea, after much research on our property, that I had any idea was going to come up. So I would like to go on the record as saying I am against any kind of mining or activity at all in the valley. And that's it.
Thanks. Wendy, can you mute yourself, please?
Yep.
Thanks.
As soon as I figure it out.
Great. So final call for any members of the public. Great, then now I'll go forward and call for any questions from board members, for staff, applicant, or other speakers. Seeing
Mr. Chair, Chair Ukaili, it would be appropriate for the two parties to be able to respond to the public comments at this time?
Yeah, I was getting to that. So hearing no questions from the board members, I'd like to offer the staff chance to make any rebuttal or clarifying statements.
Thank you, Chair. Just a couple of clarifications and points I think that I'd like to make in response to Mr. Peters' statements. I think one of his arguments that the outside storage on the property for any time would have prevented a lapse in that provision is expressly in contrast to what the Court of Appeals determined in the decision as we read it. So I don't see that argument as something that preserves the special use as it was defined for us to consider through the Court of Appeals. And also the argument that the 5-year lapse provision only goes back to 2012 is also not consistent with the application and the wording of that regulation. That 5-year lapse provision goes back in time till the time that provision was adopted into the code. And so it is that look back to 2006 when we know mining ended. It's been stipulated to, as Mr. Silvestro said, and we looked at that period 2006 till present, and that's where we find that mining did meet that no activity for a continuous 5-year threshold. So with those clarifications, I think I'll leave it to any other questions if you have some.
Thank you. At this point, I offer the applicant an opportunity to rebut any comments made by the public or staff.
Chair, would you like to hear from Mr. Silvestro first on this, or would you prefer to hear from me?
I was just planning on, well, Larry.
County attorney had said him, so I wasn't sure.
Yeah, thanks.
Save Our St. Vrain Valley has been a party to these proceedings, so it would be appropriate for Mr. Sylvester to also have the chance to comment.
Okay, thank you. And thanks for raising them, Mr. Peters. I'll let Save Our St. Vrain Valley go first, and then Mr. Peters will get the final word.
Thank you all. I don't have much to add. I think, I went after Mr. Peters. So to the extent that he's going to respond to what I had to say, I guess he'll get the last word. But I think I'd leave you all with sort of 2 key points. One is the purpose and the unambiguous meaning of the lapse provision as confirmed by the Colorado Court of Appeals. And that's a situation where someone who has this special license to do something that's not otherwise allowed, no one else in the county can do it without obtaining this approval. They do have responsibilities, and one of those is to ensure that the permit remains active. And that's not what happened here. It's now been ongoing 16 years of non-use. To the extent that they want to engage in this special use activity at this site, then I think it's incumbent on them to obtain a new approval. And that'll be for the benefit of the county and all of the county citizens to have a new application presented, vetted by staff, weighed in by, referral agencies and other government entities that have something to say about this, and ultimately put to an up or down vote. But there's no basis to salvage the abandoned use that's been dormant for so long. The other point I would make is that, at certain points, I think opposing counsel said that it was our burden to show that there was a lapse. That's not really where we're at in this stage of the proceeding. The question now is whether or not you all think that Director Case erred in his interpretation and application of the 5-year lapse provision with the benefit of the Court of Appeals decision. And ultimately, I think you should defer to what he's decided here. I haven't seen any evidence that would change or draw into question his decision. And, Chairman Ukaili, to your point, exactly when you pressed the applicant or the appellant on specifics of, okay, so what activity you're actually saying happened at what time? They've got a lot of paper that they've put into the file, 5 years later, but they can't even answer basic questions. So, I think the easiest thing to do is just to default to the fact that there's been no mining. They stipulated to that. Court of Appeals confirmed that. This permit's lapsed, and if they want to engage in mining at this site, there's a procedure for them to do that. But this proceeding has sort of reached the end of its life here. Thank you all.
Thank you. Mr. Peters.
Thank you again for the opportunity to present on this, members of the board. I want to say, although I do not believe that it's relevant to the consideration here, that it is the case that this quarry, or rather this operation, does provide needed building materials growing on the growing Front Range. There is a need for the materials that come out of this site, for roads, for schools, for driveways, to construct what is constructed on the Front Range. And the question is not whether that material will come to the Front Range, but where it comes from. And the better location is to have it close to the place where it is needed. But with that in mind, the focus of today's appeal, the question in front of the board is whether Director Case erred in making his determination that the appeal, or rather the special use permit here, had lapsed. The Court of Appeals did not decide that the special use permit had lapsed. It said that Director Case had misinterpreted the lapse provision and that he needed to go back and figure out what the correct interpretation of that provision is, or rather the Court of Appeals told him what the correct interpretation of that provision is. And it said that activity under the permit, the word activity, which Mr. Silvestro has identified, and some other folks have too, that activity under the permit means activity directly related to the special use or the authorized accessory uses. Those authorized accessory uses are clear. They are specific in the approval resolution. The question is whether those uses occurred. And we have a declaration from the Western Lands Manager for Martin Marietta, someone who was there with Lafarge before, someone who has been on this site for 2 decades, who is familiar with the operations out there. And that declaration makes clear that those accessory uses have occurred on this site. The question is simply whether they did. And you see that the stockpiling occurred. You see that the hauling occurred all during this operative period that SOSVV has focused on. You see that the equipment was maintained. These are all specific uses that are outlined in the special use permit. So I understand that Mr. Silvestro might say that there's not specifics here, but in fact there are. We have these specific timeframes for all of these uses, when they began, when they continued, when they ended in the case of the portable office, saying that we replaced the portable office in 2016. So I just want to be clear about this, that history of the uses is both what the Court of Appeals called for when it said, please go back and understand whether there are accessory uses authorized under the permit occurring out there. And we put that together because that's the direction the Court of Appeals gave us. So the direction here is to understand whether Director Case correctly applied the law, and then furthermore, whether equitable considerations would support continuing to hold this permit out here. And the final thing is that, or rather, I think the final consideration that some folks have suggested this board should make is to whether mining is a good idea on this site. And the Board of County Commissioners, when it approved SU 9618 in 1998, or excuse me, when it approved it in, yes, it was 1998, that mining needed to commence by 2003, was that mining could occur on this site through 2033. That was the determination then. The question now is only whether the lapse determination was correct. So it's not a question of whether a new special use should be approved, but rather whether he erred in making his determination. Our position is, for all the reasons that I've described, is that he did in fact err. The correct decision is to reverse his determination and find that the permit did not lapse. Thank you very much for your time.
Thank you. At this point, I will close the public hearing. And I would like to open it up for board members' observations, discussions, and conclusions about the required criteria based on the testimony and documents presented. Seeing,
I can take a cut at just my reaction to what I've heard for people to react to see what I'm missing or other perspectives, if that's appropriate, Mr. Chair.
that would be fine, thank you.
It seems to me that after listening to the testimony that we've heard throughout the afternoon, that it seems clear to me that the court, and based on what the court's direction, that a lapse has in fact occurred, and that the definition of accessory use should be that which is associated with the mining and not kind of preparatory or not directly related. In fact, if the definition I understood from the appellant is true, that as long as they change oil in a machine and move some gravel about, they could extend their permit without any mining for generations. And I don't think that was the intent. And I think the courts gave clear direction that should not be the case. So I think Director Case was correct in his interpretation of that a lapse had occurred. It also seems clear to me from the record that through time, the county has reminded the various applicants that they need to renew the permit period or take action, and that a lapse may occur. So it is not a new concept, or it should not be a surprise to anybody that a lapse might occur and that there was a risk of that happening. So for those reasons, it seems to me that Director Case was correct in his decision, and I am thinking that it would be appropriate to uphold his decision.
Thank you. Do any of the other board members want to respond to that or share thoughts?
Chairperson Ukaili, I would like to be heard.
Thank you.
Thank you, Chairperson Ukaili, and thank you everyone who's spent their time this evening giving a series of very thoughtful comments on this issue. I was one of the two remaining Board of Adjustment members who were here for the original appeal several years ago of this matter. And in that appeal, we rejected arguments at least of the same flavor that Martin Marietta is trying to make here with respect to what kind of work is required to maintain the active use that would prevent the lapse of this permit. I in that prior matter was concerned that Martin Marietta was trying to expand the definition of what constitutes an activity under the permit, such that it would encompass virtually anything that was happening out there on the land, so that they could acknowledge on one hand that really nothing had been done with the property for many years, and on the other hand resist the lapse of this permit, which I think is a matter of relatively important public policy for Boulder County. And I've reviewed carefully the Court of Appeals decision, in part because I'm quoted in it on paragraph 41 relative to that prior opinion. I've reviewed the record in this case very carefully. And I've of course listened to the arguments made today, but I just frankly don't see any basis for Martin Marietta's argument that there has been active use, either an active accessory use or an active use under the special use permit that would prevent this permit from lapsing. I find the arguments made by Martin Marietta's counsel to be logical and an evidentiary stretch. I don't find them persuasive, and I would find that under the plain terms of land use code that this permit's lapsed. I would also say that I don't think that there's any basis for an equitable argument that the permit should be upheld even though it's lapsed. I mean, frankly, Martin Marietta is one of the more sophisticated actors on the global stage. It's a very large company with legions of engineers, land use specialists, and attorneys at its disposal. Bart Marietta is also a mining company that understands the importance of land use codes, and it knows how to, through its agents, read those codes. The Boulder County Land Use Code is clear about what the requirements of the law are. It's clear that Martin Marietta didn't follow the requirements that should have followed if it wanted to keep this permit active. And I don't think Martin Marietta could have reasonably relied on the frankly relatively sparse record of communications from the county to conclude that somehow this permit was protected from lapsing. Anyone with a law degree or a specialty in land use or mining engineering could have looked at this and told you exactly what was going to happen. And so I look at this and I don't see a basis for overturning Director Case's decision. And I hope that at least a couple of my board members join with me in that position so that we can uphold that decision and allow this permit to finally lapse as in a relatively final way. Thanks for everyone's time. I appreciate it.
Thank you. Any of the other board members want to share thoughts?
Chairman Ucali, I'd like to briefly share my thoughts. I'm the other of the two members of the board that were members of the board at the time of the original ruling. And I'm one of the two that voted to uphold Dale Case's determination in the prior case. We relied on the opinion of Eric Heil, another attorney, expert in land use and in land law and a prior determination, case law, in which a special use permit had been upheld when the activity was not the direct activity of that special use permit. It was a gentleman who was burning tires on a property where the special use permit was for something else. The exact nature, I don't recall. At that time, it seemed to be consistent with the case law. The determination was appealed to the Court of Appeals. We learned that that was not a precedent in this case, and that decision was reversed. Dale Case has gone along with that reversal by the Court of Appeals, and I have no reason to think that I have a better insight into this than the Colorado Court of Appeals. So I would vote in this case to continue to uphold the determination of Dale Case, although he's reversed his determination of the previous time. I think the Court of Appeals has been very clear in what could be considered and what should not be considered. And I don't think that Martin Marietta has presented any information to validly for this body to oppose that.
Thank you for sharing that. Mr. Walters.
Yes, this is Bill Walters, board member. There's been a lot of work put into this, and I appreciate all the people that have brought documentation forward and spoken their minds on this. In my opinion, I think it's pretty much shut and dried that there has been no mining operations there. And so that really leaves us with accessory operations. At this time, I'm just not convinced that the operations that occurred really fall under the special use permit and what was intended to be the case there. I've heard really no good arguments on equitable considerations there either. So my view now is that I would support the latest recommendations of the director.
Thank you. So at this point, I would ask, what's the pleasure of the board?
If it's appropriate, I would move that the board uphold the decision of Director Case in this matter.
I will second that motion. I should have said this is Eric Mouts. I will second that motion.
Okay, I appreciate that. Mr. Gertzel, do you want to add any more detail in terms of the basis, like referencing the analysis section of the staff memo?
I would feel comfortable if Mr. Ukele, if you would do that.
Okay, thank you. I would offer a clarification that in this case, which is AP-2022-003, that the basis for the motion is articulated in the analysis section of the staff memo, as well as what the board members articulated during the discussion portion that preceded this.
I'm comfortable with that friendly amendment.
May I interject briefly just to ask a question of our board legal counsel in regard to that amendment?
Yes, please.
Okay, so Mr. White, I thank you for being present and being here to assist us. My understanding is that typically the Board of Adjustment doesn't cite a specific reason for its decision in a matter like this. And I guess my question, my concern is that, again, my understanding is typically the decision of the Board of Adjustment in a matter like this can be upheld, on the basis of any evidence or reason in the record that would allow it to be upheld. And I'm concerned whether trying to get into the specifics of our decision in the manner that Chairperson Ukele has suggested would have any effect on the posture of this matter were it to be appealed. My suspicion is it does not really matter if we say the basis or not, but I'd like your advice on that, Mr. Hoyt. What I don't want to do, to put it in context, is I don't want to state a basis here at the end of the meeting, have it be a summary statement that ignores some other important piece of evidence or issue that was raised during the hearing that could be used to support the decision. And that's always the risk. Mr. Hoyt, what do you have to say?
Right, I do understand your concern. I think that my interpretation of Mr. Ukele's amendment there was that the basis was the staff analysis from Director Case, as well as the discussion that the board members have had. I don't know if he wants to include in that any evidence that was elicited by, brought forth by Mr. Silvestro or any of the other participants in the hearing. So that's the only thing I would be concerned about, I guess.
Eric, you're on me.
Sorry, I hit the button and it didn't unmute me. My understanding is typically, we ought to make our decision based on the entirety of the record before us. Testimony that's been taken, documents entered into the record and so forth, presentations of all parties. And I would, would you be more comfortable if the motion was amended to specifically incorporate the entirety of the record? in the case. Is that an improvement with you, or is it unnecessary? Am I worried about nothing?
Yes, that's appropriate.
Okay.
Would that be a friendly amendment to your amendment, Mr. Ukele?
I'm open to that, yes.
Okay. I would make a motion that based on the entirety of the record presented to us, that we uphold Director Case's findings.
Thank
I
you.
second that motion.
Thank you for the second. Any discussion? Hearing none, I'll take a roll call vote. This is Chair Ukele, and I vote aye to the motion. Board Member Mounts,
I vote aye. This is Board Member Mounts.
Board Member Gerstle,
George Gerstle, board member, votes aye.
Board Member Rudge,
Board Member Scott Rudge, I vote aye.
and Board Member Walters.
This is Board Member Walters and I vote aye.
Thank you. So this is Chair Ukele. The motion unanimously passes. Unless anybody has anything else, I will thank everybody for their time and their clear presentations, and I will adjourn the meeting.
Thank you all.
Thanks.
Thanks, everybody.